بسم الله الرحمن الرحيم فجعله غثاء نحوا سنقرئك فلا تنسى إلا ما شاء الله.
بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا ونبينا محمد وعلى آله الطيبين الطاهرين واللعنة الدائمة الأبدية على أعدائهم أجمعين إلى قيام يوم الدين. My beloved sons and daughters, shuyukhs of the future, Assalamu alaikum wa rahmatullahi wa barakatuh. بسم الله الرحمن الرحيم رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. So inshallah today we have lesson 7 from Minhaj al-Salihin. We are going to continue these lessons of Taqleed. We had missed rule number 13 and 14. So inshallah today we are going to do ruling number 13 and 14. And then we are going to talk about ruling number 22, 23 and 26. These are important rulings, and inshallah we will try to discuss them more thoroughly. So if you can look at the slide, I've just kept an important note, because the Minhaj al-Salihin, the translation which was done was before 2009's edition, and that's why many audio files, they are not exactly in the same wordings of the PowerPoint presentation. So PowerPoint presentation has been edited according to the edition after 2009, because 2009 Ayatollah Sayyid Al-Uzma Sayyid Ali Sistani, may Allah protect him, he changed a lot of rules. So we changed the PowerPoint presentations, but the audio files are still, we tried to cut off the audio files from the old Masail, but in case if you see there is a discrepancy between the audio file and the PowerPoint presentation, so just know that the audios were not being edited properly from the old version, but the PowerPoint presentations are according to the edition of 2009 Minhaj al-Salihin of Sayyid Sistani. So this is what I'm trying to say in this slide. The rulings in the PowerPoint presentation has been edited according to the edition of 2009, which has certain significant variations from the previous version. Therefore, if when audio lecture differs with the written PPT, therefore on those few changes or variations, please observe the written PowerPoint and don't depend on the audio when you have a clash, or when the audio clashes with the written. Just go with the written, because written is the latest edition. So the latest edition is available on the website of Ayatollah Al-Uzma Sayyid Ali Sistani. I've kept the link on the PowerPoint presentation. You can go there and have the whole edition of Minhaj al-Salihin. We'll go to the next slide. Okay. So let's see what does this slide have to tell us. Rule number 13. إذا قلد من لم يكن جامعا للشروط. A guy did taqleed to somebody who was not qualified. That means the conditions of marja' taqleed did not fulfill. والتفت إليه بعد مدة. And after some time he realized, oh my goodness, I've been doing wrong taqleed. I've been doing taqleed to an unqualified marja'. There are many scholars, they have presented themselves as maraja', but they are not qualified. They don't have qualifications. They don't have scholars considering them mubri' lidhimma. That means worth of relieving the liability or the responsibility of a following person. So therefore, there are plenty like those, and they give fatwas also, they give rulings. But my responsibility is not to just follow the one I love, his fatwas are easy, or his fatwas are nice, or his fatwas are flexible. No, I have to look at the qualifications. And we mentioned this. We mentioned this before, that especially our young generation, unfortunately, not all of them, many of them, they don't have the understanding of the concept of taqleed. They just say, oh, this marja allows shaving of the beard, for example, or this marja is easy, or this marja allows the fasting, like in the northern countries, in Sweden and northern countries, the fasting, sometimes we have to fast 20 hours. Oh no, I'll do the taqleed. Many youth, they call me, I'm going to change my taqleed to this marja who says fast 14 hours. Or to this scholar, there are some scholars, English-speaking scholars, they call themselves scholars, and they're not even qualified as ayatullahs. They say that no, you can fast like 14 hours, 18 hours. First of all, you are not qualified as a marja taqleed. There are people, they are not qualified as marja taqleed, even if they are marja. But then you need to do taqleed to the a'lam, most knowledgeable. So for me, just because he relieves me fasting remaining of the time, just because he says that, oh, the fasting should be on an average time. I mean, we refer to the average whenever we do not have evidence. So whenever we have evidence, we have to act, practice according to the evidence. Majority of the maraja, they looked at the verse of fasting. I'm giving you an example what type of dilemma we are living in this era, especially in northern countries where the fasts are so long, especially in summer. So the dilemma is, Quran says, ثُمَّ أَتِمُّ الصِّيَامَ إِلَى اللَّيْلِ, then observe the fast till layl, night. A very clear wording. There is no confusion in it. So I have to stick to the wording. Now there are some scholars, especially some here in like English-speaking scholars, they started challenging the maraja, challenging the fatawa. They're not qualified for that. They have not even studied 1/10 of what these great maraja have studied. So they say fast only 18. Why? Because the average fasting is in the Middle East, and the people in the Middle East, they fast average fasting. Average fasting, the fasting should not go beyond average or above average. The problem is the concept of average. I'm not a marja, but I asked the mujtahideen, and they say we cannot go to the average if the evidence is clear. If the evidence is sharp and clear with the wording night, the night is known that it comes on the sunset, after the sunset, or with the sunset. It's known. So there's no doubt in the night. There's no confusion. So there's no need to refer to the average, concept of average. When do I go to the concept of average? When there's a confusion. When there's a confusion. For example, I don't know, these songs are suitable for corrupted gathering, not suitable for corrupted gathering. The Sharia, the Islamic legislative system, the ahadith, they did not give me any criteria for songs which are suitable for immoral gathering. They did not give me what type of beats, what type of sound, there's nothing specific. So then we have to go to the urf, to the common consideration, to the community, to the society, whatever they consider immoral or suitable for immoral gathering, we should not be listening to those. And this might differ from community to community. So this is an example of referring to an average. Now when we come to the rule of fasting, the time of fast has been decided and has been fixed. Layl, sunset. There's no doubt in the night. So from where did this average come? So it's a very clear, mujtahideen, like several mujtahideen, I asked them that why don't you accept this average concept, where one or two, they are talking about this average. They say, why should we go to average when Quran clearly defined the time? and defined the limits. So whenever the limits are defined, there is no need to go to average. Like for example, the hand in the wudu. The limits are defined. So we have to stick to the limits. We cannot go with the average hand. Yes, when there is a doubt, is this hand am I supposed to wash this hand this length or not? This is not mentioned in the Sharia. This extra hand or shorter hand. So let's go to the average. So see, whenever the limits are not there, whenever the ruling of the limits are not there, we go to the average. Here, the ruling is there. ثُمَّ أَتِمُّ الصِّيَامَ إِلَى اللَّيْلِ. From this, all the maraja, majority of the maraja, especially the top ones who are who are very highly knowledgeable, they have taken the evidence directly, clearly, because it's obvious. There's no ta'wil, there's no interpretation to it. So therefore, this is just an example how people, they are deceived by presenting easy rulings. Come on, follow this marja because it's easy ruling. That's not a criteria. I mean, anyhow, whoever wants to follow, whoever they wish people, they will be responsible on the day of judgment for their choices. But our duty is to just explain and elaborate. And whatever choice people make, we have to respect them. Regardless, respect is very important. Yeah, when we discuss very thoroughly, but at the end of the day, they are our brothers and sisters in the love of Imam Ali alayhi salatu wasalam. So we respect every peaceful human being. Why shouldn't we be respecting our peaceful beloved brothers in our school of Ahlul Bayt? But we can agree to disagree. So the thing is that sometimes people, they follow unqualified mujtahideen as maraja. Nobody has considered so and so marja, so and so mujtahid as mubri' lidhimma, relieving. Because I am a lay person, how will I know that he is qualified? I have to refer to mujtahideen, those who can tell me, yes, this marja is a marja, he's qualified, this marja is not a marja, he's not qualified, his researches are weak. So yes, of course there are other factors. Unfortunately, they get into like nationalism, like favoritism, like easyism, easy masail, easy laws. All these kind of factors go in nowadays directions. But this ruling says that if after some time I found out, oh my goodness, I've been referring to a marja who was not qualified. So what should I do here? Then we see here what does this slide tell us. So ruling number 13, I'm going to read the Arabic portion and try to translate in English, and then you can check the English part later on, because my aim is that our Hausa students, they learn the Arabic language also, and they try, because this helps them to understand the terminology, fiqh terminology, and it's a kind of Arabic lesson, reading lesson combined with fiqh. And this is how our scholars, they do in the Hausa. They let the student read. So I'm going to read on your behalf, but you try to read by yourself and try to understand the meanings as well. So ruling number 13, مسألة 13, إذا قلد من لم يكن جامعا للشروط. If a person follows or does taqleed to someone who was not qualified, did not fulfill the conditions, والتفت إليه بعد مدة, and after some time he realized, oh my goodness, he became aware, فإن كان معتمدا في ذلك عن طريق معتبر شرعا. So if his relying on that marja was not qualified, was based on proper methodology, right, reliable sources, reliable religious method, وَقَدْ تَبَيَّنَ خَطَأُهُ لَاحِقًا, and later on he found out. So then we have two types of ignorant. That means he was ignorant, he did not know. So we will say there are two types of ignorant. So I have explained this ignorant, two types of ignorant previously. Intentional ignorant, that means you doubt. You hear a lot of people saying things, so you need to double check. You need to check the qualifications. You did not. You ignored the alarms and alerts of the people and awareness and directions of the people, especially qualified people, scholarly people. You ignored those signals. That means you are intentionally ignorant. But let's say you did not ignore. You double checked, you found out through the resources which you had that he's still qualified. Later on you found out from other resources, no, he was not qualified, which were stronger resources. So at that point, what will happen? That you were ignorant, but unintentional. You did not mean to remain on ignorance. Okay? So that is unintentional ignorance. Either you did not know, either you never had doubt, either you never have any kind of thing, and you remained on the taqleed. Or you tried to find out, but you did not find proper resources. So you stayed on that wrong taqleed. So this is unintentional ignorant. Intentional ignorant, you ignore. You ignore the signs, you ignore, and you stubbornly do the taqleed. So the Sayyid says, if you can look at this slide. So now he realized, خطأه لاحقا كان كالجاهل القاصر. If he relied on proper religious resources, and then he found out that those resources had errors in it, like he thought that these were qualified, they came out to be unqualified, then he is qasir. Jahil al-qasir, ignorant, unintentional ignorant. It was not deliberately. If no, he found, he did not depend on religious resources. He made his choice by himself. He said, no, I'm going to follow this. It's very easy. He allows shaving of the beard. He allows this and he allows that. And he is very modernish and this kind of thing. And those like glamorous titles. We will say, okay, that means you did not follow proper resources. You just followed yourself. That means you were following somebody in deliberate ignorance. So you were deliberately ignorant. So he says here in Sayyid Sistani, so it depends in the excusability. وَيَخْتَلِفَانِ فِي الْمَعْذُورِيَّةِ وَعَدَمِهَا مَعْذُورِيَّة من عذر معذرت خواہ معذرت چاہتا ہو اعذرنی, it's from عذر, excuse me. So in excusability, his excusability will be depending on what type of ignorant he was, what type of ignorance he had. So it will depend. Should he be excused? If it was undeliberately ignorant, so yes, his excuse will be accepted. Otherwise, his excuse will be not accepted. That's number one. Number two, كما يختلفان في الحكم بالإجزاء وعدمه. And even, let's say, in both cases, it will depend on what type of conflict in act happened. Were his acts conflicting the recent marja, like previous acts were conflicting the marja which he was supposed to do? What type? Were those acts from those forgivable acts or unforgivable acts? All these things I'm not going to repeat here, and Sayyid also is not repeating here. He says it all depends. His excusability, inexcusability depends on what type of ignorance. And also, should he redo the previous acts, or should he suffice with those previous acts? Those also depend on which type of act and in which case the conflict happened. That has been mentioned in ruling number 11 previously. So please go refer to the explanation in ruling number 11 if you were in this case and you wanted to find out your situation. So you should refer to the ruling number 11. Ruling number 14. Ruling number 14, let's look at the slide. This is like I used to do taqleed to a marja. Like for example, I did taqleed to Sayyid Abul Qasim al-Khuwi rahmatullah alayh, because strong evidences were pointing towards his alamiyat in that time. So then I refer to the living marja, let's say for example Sayyid Sistani hafidhahullah, and now I totally referred to Sayyid Sistani. For example, I found Mujtahideen, they said Sayyid Sistani is a'lam, more knowledgeable than Sayyid al-Khu'i, which until now we don't have any type of clear evidence. Most of the Maraja, nobody declares such kind of declaration. So I'm saying hypothetically, let's say for example. So let's say I found out by proper resources, by Ahl al-Khibra, Sayyid Sistani was hypothetically more knowledgeable than Sayyid al-Khu'i. So I had to refer totally to Sayyid Sistani. Now, can I go back to Sayyid al-Khu'i? So he says here, مسألة 14 لا يجوز العدول إلى الميت ثانيا بعد العدول عنه إلى الحي. It is not permissible to go back to the taqleed of the deceased mujtahid after leaving him, after abandoning him, after changing بعد العدول عنه إلى الحي, after changing his taqleed, after leaving him to a living, after leaving his taqleed to a living mujtahid. والعمل مستندا إلى فتوى. So no, you cannot go back and do the taqleed of the deceased after you did the taqleed of the living mujtahid. Let me just remind you. Remember my example here, what I'm saying. If a mujtahid was most knowledgeable, like Sayyid al-Khu'i to many of the scholars. So Sayyid al-Khu'i rahmatullah alayhi died. After Sayyid al-Khu'i, the evidences were pointing at Sayyid Sistani. For example, let's say for example, though in some cases some of the scholars had referred immediately to Sayyid Sistani after Sayyid al-Khu'i without referring to Sayyid al-Gulpaygani or Sheikh al-Araki or any other marja. So let's say these scholars and these mu'mineen who were doing taqleed to Sayyid al-Khu'i and there were evidences that Sayyid Sistani is more knowledgeable than Sayyid al-Khu'i, then they have to totally switch their taqleed to Sayyid al-Sistani damadullah. But however, what happened? They realized that no, those who told us that Sayyid Sistani is more knowledgeable than Sayyid al-Khu'i, there were some errors, they were mistakes. So now you have to go back to Sayyid al-Khu'i. Why? Because Sayyid Sistani says that your referring was incorrect, like in one of the rulings we had mentioned. Your referring was not correct. That means you never referred to me, or to Sayyid Sistani. That means you never referred to me. Yes, you said I am referring, but it was incorrect. So actually, in reality, you were supposed to remain on taqleed of Sayyid al-Khu'i. So your referring to me was an error. In this case, you have to refer to Sayyid al-Khu'i. What we are discussing in this ruling is, after you realize properly that Sayyid Sistani is a'lam, once you did taqleed to him, totally switched to him, then you cannot go back to Sayyid al-Khu'i. That's what we are talking about here. I hope this is clear, the two examples. So let's go back to the slide. So it is not permissible to switch back to the deceased mujtahid after leaving his taqleed to the living mujtahid and practicing or acting based on the fatwa of the deceased. You cannot. والعمل مستندا إلى فتوى الميت إلا إذا ظهر أن العدول عنه لم يكن في محله. Unless if you realize no, there was an error in the testimonies when I switched to Sayyid al-Sistani, there were error in the testimony. In that case, you have to go back. So إلا إذا ظهر, unless if it appeared or a person realized or found out أن العدول عنه لم يكن في محله, switching from the deceased Sayyid al-Khu'i to Sayyid al-Sistani was incorrect, not done properly. كما لا يجوز العدول من الحي إلى الحي. The same thing, one person cannot switch from a living mujtahid to other living mujtahid unless if the other mujtahid, living mujtahid becomes more knowledgeable than the recent mujtahid which a person is following. So, وَلَا كَمَا لَا يَجُوزُ الْعُدُولِ, it is also not permissible to switch from one living mujtahid to another living mujtahid, إِلَّا إِذَا صَارَ الثَّانِي أَعْلَمُ, unless if the second one becomes more knowledgeable. So then you have to. أو لم يعلم الاختلاف بينهما, or you don't know that there are differences between these two maraja. You don't have any knowledge, because we said, why do we need to look for the a'lam? We need to look for the a'lam in case of the most knowledgeable. I mean, in case of the differences between the maraja and mujtahideen, then if they differ in certain masail, then you have to find out which one is a'lam. If you don't know that they have differences, then you can choose eeny, meeny, miny, mo, presto, whichever you want, because you don't know that they have differences. And that is, of course, not the real case. Practically, they have differences. But let's say somebody said, I don't have any knowledge about their differences. They're all same. So in that case, if that is really a case, then a person can choose any of these maraja, and he doesn't need to look for the most knowledgeable. So the most knowledgeable is effective in the case of differences in rulings amongst them. Let's move to the next slide. Partial mujtahid. Ruling number 22. So some maraja, they do not give rulings in the entire Tawdih al-Masail, book of law. They just give ruling in chapter of Salat, for example, or chapter of Zakat, or chapter of Khums, or chapter of business. So they are partial mujtahid. Partial mujtahid. So let's see. Ruling number 22. Al-Mutajazzi. Mutajazzi is from juz', from part. Al-Mutajazzi fil ijtihad, a person who is partially mujtahid, يجوز له العمل بفتوى نفسه. It is permissible for him to rely on his own fatwas in that area which he is excellent in it, which he is mujtahid in it, which he knows the laws and he deduces the laws from its resources for him. What about others? Can others follow him? بل يجوز لغيره العمل بفتوى. More than that, others also can act on his fatwas. They can practice his fatwas upon his fatwas. إلا مع العلم بمخالفة فتوى لفتوى الأعلام. Remember the differences? Unless if they find out this partial mujtahid has differences with the marja' who is a'lam, more knowledgeable, most knowledgeable. So in the case of differences, of course you have to refer to the a'lam. إلا مع العلم بمخالفة فتوى لفتوى الأعلم. Unless if you have a knowledge that his fatwa, the partial mujtahid's fatwas, are different than the fatwas of the most knowledgeable, or even أو فتوى من يساويه في العلم, or even fatwa of those who are equal to him in knowledge. على تفصيل علم مما سبق. With details, it has been mentioned before. You have the knowledge of it before. It has been known from before previous rulings. We had discussed this issue. Okay, here we spoke about taqleed. What about his judiciary decrees? Can he become a judge? Partial mujtahid? Can he give judiciary decrees? ولو مع وجود الأعلم وينفذ قضاؤه ولو مع وجود الأعلم. But if he becomes a judge, then his judiciary decrees are carried on, executed. Even if there was a'lam and the a'lam was opposing this judiciary decree, that's fine, because now he's acting as a judge. And a'lam cannot nullify the judiciary decree of a judge unless if there was an obvious error in the conclusions of the judge. مع وجود الأعلم إذا عرف مقدارا معتدا به من الأحكام التي يتوقف عليها القضاء. So this partial mujtahid, can he be a judge? Fatwa, we said. In case of fatwa, he has to follow his fatwa. he can follow his fatwa. For others, can they follow his fatwa? If there were no differences between his fatwa and the fatwa of the most knowledgeable, yes. Or he was most knowledgeable in this than the a'lam. Or there was some kind of the a'lamiyah was taken. Or they did not know that there is a difference in the fatwa of this partial mujtahid or the full mujtahid. In this case, yes, a person can follow. So this is in regards to taqleed. That taqleed is deducing the law from Quran and Hadith and the intellectual concepts. The Quran was Sunnah wal Aql. What about judiciary decree? Like a judge, he has a scenario, he has people in front of him, there's a courtroom. So the judiciary decree differs from fatwa. In judiciary decree, the mujtahid has his own fatwas. But now he's going to apply on a court setup, he's going to listen to the testimonies, he's going to listen to everything going on and witnesses and testimonies and evidences and all those kind of things. And then he's going to give a verdict, hukum. See, there's a hukum, and that was fatwa. Though there is overlapping, some of the books they will consider hukum, fatwa, fatwa, hukum, because at the end of the day it's all decree. But to be more precise, fatwa is what you get out from the Quran and the Hadith, like from the resources. Hukum is a verdict given in the judiciary setup. So now we have this hukum. This partial mujtahid gave a hukum. He divorced a woman from her husband due to the circumstances he studied. Now that, like it happens, now this guy says, he comes to say this Sistani, this judge divorced my wife. He said, then go to refer to the judge, because that's a judiciary decree. I cannot nullify it. If you want, you have to present the whole case, and then we have to look into it, and we find out errors, then we can look into it. Otherwise, we cannot do anything. So it's an intellectual society. When somebody gives a decree in a court, you cannot, if you don't like the judge, you cannot go with other judge. The other judge will say, we cannot do anything. It's done. A judge cannot nullify the decree of another judge unless if more evidences had been up here, or more testimonies, some more evidences. Then they open the case back again, or they go to the Supreme Court and make an appeal to open the case back again. So it's a complicated situation. The same thing in Islamic judiciary system. If the mujtahid or a judge gives a decree, then that decree cannot be nullified by another judge. Even the marji a'lam cannot nullify the decree of this mujtahid who's partial mujtahid, is not a'lam, but he's now acting as a judge. He has looked into the testimonies. So even the marja cannot nullify the decree of a judge unless if supreme. So it's just, as I mentioned, it's a system of intellectual society. Because the judge deals with the testimonies and evidences. The marja has not seen that. So the marja will never get involved in that situation. Because the judge has been more aware about the evidences and testimonies, like witnesses, and he heard. And say, this Sistani will say, I cannot do anything. Though he's a'lam, but he cannot do anything. So it's as it is practiced in the intellectual society, the Islamic legislative system has similar procedure. So let's see. So وَيُنْفَذْ قَضَاؤُهُ وَلَوْ مَعَ وُجُودِ الْأَعْلَمِ. His judiciary decrees are executed even with the presence of the most knowledgeable. But there's a condition. Can any partial mujtahid become a judge? No. He needs to know the laws of judiciary system. So what's the condition? إذا عرف مقدارا معتدا به من الأحكام التي يتوقف عليها القضاء. If he has some considerable amount of knowledge, which is required in the judiciary system, where the judiciary system depends on these laws. Let's move to the next slide. Okay, perfect. Now, in this slide, before we go to the next ruling, it's better to understand that there are three types of decrees: hukum, fatwa, whatsoever you want to say, judgments. I will say judgment because judgment is like more flexible, more umbrella word. So there are three types of judgment. Number one judgment is on specific things. Anybody can do judgment. You don't need to be a mujtahid, you don't need to be a'lam, you don't need to be a marja, you don't need to be a judge to give hukum on the specific subjects, specific objects. Like for example, you have a cup of confused liquid. You don't know a liquid which there is a confusion about it's being alcohol or being grape juice. You don't know. It's in front of you. You did some chemical thing, or you just touched your tongue, for example. You found out, oh, it's wine. Of course, you vomited. You did not. It's wine. Just to swallow it. No, you cannot do that. Anyhow, so you just kept your. Oh, not vomited, mouth washed. So but you found out. Now you gave a decree, judgment. This is wine. This is alcoholic beverage. This is your. You don't need to bring a mujtahid. Can you just define that this is alcohol or not? Mujtahid said this is your area. This is your realm of knowledge. Just you find out. I will give you the law, the rule. You apply it. This is an application area. So it's an application area for everybody. The moon, has it been sighted or not? You don't need to go to the marja. It is your area. Yes, I saw the moon. Marjana, I saw the moon. Should I make Eid? You saw the moon. Of course, you apply the rule. But are you depending? No, it's not my area. I will need two witnesses. But if you are two just witnesses, but if you are sure that whatever you have seen is moon, then you have to act according to your judgment. So these are specific judgments, specific hukum. You make a judgment, you make a hukum on certain things. This is alcohol, this is halal, this is haram, this is slaughtered properly, this is not slaughtered. You go to the grocery, you don't need to bring the marja in the grocery with you. Or put the marja on the viber. Marjana, look at the meat. How is this meat? You put the marja on the viber. He said, what are you doing? How will I know that? What type of meat is this? Who slaughtered it? How was it slaughtered? So this is a specific area. Is this understood? Number two, fatwa. So that judgment was on specific things. Another judgment is fatwa. That means marja, and we call it hukmun shar'i also, religious rule, religious law. That marja looks into the Quran, into the hadith, concepts of the intellectual society, and gives you this book of law, Islamic laws. These are fatwas. These are the responsibility of the marja or mujtahid. If you're not qualified, you cannot give those things. First one, you don't need qualifications. This one, you need qualifications. If you're not qualified, you cannot give fatwa or a religious ruling. So that's number two. That's another thing, another type of decree. The third type of decree is a hukum, judiciary decree. That means the law is there. A mujtahid has the law. He has deduced it from the Quran and the Hadith and the concepts of the intellectual society. Now he has a courtroom scenario. In this courtroom scenario, he has witnesses, testimonies, weapons, things, evidences, whatsoever. A lot of things are in front of him. He's going to study the case entirely and then apply the hukum on this case. This is also responsibility of a mujtahid, a jurist, a judiciary person. He has to be qualified as a judge. So this is a judge that was a mujtahid, and mujtahid and judge are same. The only thing is mujtahid takes from the Quran and the Hadith, and judge applies it. So a mujtahid, judge has to be a mujtahid, okay, to get the fatwas and then apply on them. Marja does not give you the verdicts, the hukum, gives you the fatwa. You follow this fatwa, and I'll take the responsibility on the day of judgment. So he gives just the fatwa. The rest is on you. This is alcohol, this is meat, as we mentioned. So let's look at this slide and just go through them quickly. There are three types of verdicts or judgments, hukum. mawdu', implementing a fatwa on objects like moon sighting, or fatwa on stating that this drink is alcoholic or impure. Anyone can issue such hukum, which is a kind of a judgment, and assume responsibility. Defining or specifying object is not limited to the mujtahid. If mujtahid wants, yes, he can. And if he gives, it's nice to follow a mujtahid. And then we have this hukum khas, which is a judiciary verdict, specific case, a verdict on judiciary matters surrounding disputes and penalties only in the court of law, restricted to a mujtahid. A non-mujtahid cannot perform this kind of, cannot issue this kind of verdict. Yes, what they can do is, they can do mutual agreements, which we call al-musalaha. Al-musalaha, like sulh, between disputes, between disputed parties, but cannot issue a judiciary decree. And then we have the hukum am, general case for the public, a verdict on a political matter, since it may involve serious matters and enormous disputes. Hence, some scholars require a political leader, hakim, to be a mujtahid too. If not, then under such political leader, such political leader should be under a supervision of a mujtahid. So, as I mentioned, the second part, giving a judiciary decree. Like for example, for me, or people like me who are not mujtahid, if people, they come to us with their disputes, we tell them, we are not mujtahid, but what can we do? If finding a mujtahid was difficult, getting a mujtahid from Qom, Najaf, Lebanon, wherever there are mujtahideen who are judges, they might be overloaded, overwhelmed with a lot of cases. So what will we do? I mean, there are sometimes cases we need to solve them. So what we do is, we don't solve them based on the judiciary matters, because we are not mujtahid. But we use those laws and we try to do mutual reconciliation. We try to do sulh. Okay, why don't you give compromise a little bit? You compromise a little bit. Just you both are brothers in Islam. Just respect each other based on the mutual respect. You are all followers of Ahlul Bayt. Nobody's perfect. We all make mistakes. We all have errors. Why don't you guys like come together and just settle? Make a settlement, mutual agreement, mutual settlement. I cannot say, oh, you have to give this to this because it is this. I'm not a mujtahid. I should not be doing it. Yes, if the evidences and all the things are clear, I can say, okay, according to the rules and regulations of judiciary system, most likely you are mistaken. So you have to compromise and help them. But I'm not giving a judiciary decree. I'm not qualified. But I'm telling you, if a judge would decree, he might consider you made a mistake, because there are so many witnesses. They are considering you are the one who offended that person. Why don't you apologize to him? It will be nice. So we try to do some kind of reconciliation, that both parties agree, or at least the guilty person tries to confess and corrects the mistake by himself without me giving a decree, or forced to give a decree because I'm not qualified to. So this is something which was about. And the third one which I mentioned was, like for example, there are some mujtahideen, they say that a political leader must be a mujtahid too, because it involves a lot of rights of the people. Rights, or financial rights, whatever rights, economical, social rights. It depends on a lot of rights, solution of the rights, solving the rights. So a political leader, because to give a political decree where there might be bloodshed involved, problems involved. So it's a very difficult, complication position. So a political leader must be a mujtahid too. If not, if a political leader is not mujtahid, he should be under the supervision of a religious authority or religious judiciary system, so that the responsibilities are taken by proper qualified people. And this brings me to the three types of authorities. A mujtahid, if a person is mujtahid, that means he reached the level where he can deduce the laws from its resources. So he's a competent person, understands the Quran and the infallibles narrations, alayhi salatu wasalam, and the concepts of the intellectual society, and he can come to conclusion. So he's a mujtahid. Now every person who becomes a mujtahid, he can practice three types of authorities. Number one, and I mentioned this previously in a different way, I'm going to put it now from the aspect of authority. So every mujtahid has the right, but if he does not practice three authorities, it's up to him. That's according to Sayyid Sistani, that every mujtahid has the right. If he chooses to practice this authority, it's up to him. The second authority, it's up to him. The third authority, it's up to him. Three authorities, it's up to him. What are these authorities? First authority, he has the laws from its resources. He has the right to present it to the lay people that you can follow me. I'm giving you my fatwas. So wilayatul ifta, authority of giving fatwa to others so that they follow. So now he's authority. He's telling the people, you can follow me, I'll take the responsibility. That's wilayatul ifta. Like majority of the maraja, once they put the book of law, qualified, not qualified, that's another thing. But once the book of law is presented, that means the marja has taken the responsibility, the authority of giving fatwa to people, that if any confusion happens in fatwas, you can come back to me. And if there is something which is not in my book, come to me, I will give you the fatwa. So that's authority of fatwa. The other authority is wilayatul qada. That means any mujtahid, if he doesn't want to be marja, he can become a judge, the qadi, wilayatul qada, the judiciary authority. So any marja can become a judiciary authority. Sayyid Sistani does not choose, because the responsibility of the marja is too huge, and judiciary is an. So there are maraja, they might give you judiciary issues in certain cases, or certain cases they take, but there are maraja, they cannot take cases because they are too overwhelmed with lot of work of the marja'iyya. That's number two, the judge, that's another. So every mujtahid, if he becomes a mujtahid, he has the right to become a judge. That means apply his rules on the court setup. The third one is wilayatul hakim, the hakimiyya. That means this marja becomes a political leader. A mujtahid becomes a political leader. The obvious examples are there, like in Iran. So a political leader, he has the right, if he's a mujtahid, then he has the right to become a political leader, take the whole political responsibility of the country or the society or the community he lives in, and he has the executing authority as well, because political leader should have the executing body with it. Otherwise it will be just like a marja. He will not be able to execute, because it's like a judge. A judge needs an executing body who will execute the decree. The political leader needs to have an executing system where they will execute the political decrees like it is practiced in Iran. So there's a political system, a marja is leading the political system, and then there is this executing body which is inside Iran. So that's why outside of Iran, there is no executing, for example, there's no executing body for the Iranian Islamic system. So that's why the political authority of hakim is a practice wherever there is an executive system. Beyond the executive system, it is just a marja'iyya, a marja, because there is no executive body. That means his rulings will be like fatwas. So people, they practice, they don't practice. So he cannot use the executive system outside of Iran. For example, there's a lot of details in this, but I'm just giving you a kind of basic information that when can a mujtahid become a political leader, where he has an executive body who executes his decrees on a political level, social matters, any type of matters, political matters, financial matters, economical matters, whatsoever. There's a vast hand of a marja with an executive system. So this is the third one. Now this third authority, for example, say the Sistani, he doesn't have this executive system, but there are cases he has given a political decree where the followers, they have executed. Like for example, defending Iraq from the terrorism. These terrorists which came from different parts of the world to destroy Iraq, from the West and from the East and from the Arab world, every terrorist, every type of terrorist, Western, Eastern terrorists, they came and they want to destroy Iraq. So now, say the Sistani had to give a decree to defend Iraq's sovereignty, Iraq's peace. Iraq's northern parts were occupied and nothing was being done. So say the Sistani had to use his ijtihad, a political, he's not a political leader, but he used a political decree where he was able to execute all the Iraqis towards going and fighting the terrorists and eliminating, because fighting the terrorism has become a global political aim for many countries of the world, except for those who are producing terrorists. So therefore, say the Sistani became part and parcel of the global movement and effort to eliminate terrorism and the terrorists, especially where he has the authority, like in Iraq. Outside of Iraq, say the Sistani does not have the authority, so therefore he commanded the Iraqis to go and defend Iraq from the evil and the terror. So he's not a political leader, but he used the political authority. So any mujtahid can practice authority of giving fatwa, authority in the courtroom, judiciary, or authority on the political level. So let's go through these slides quickly and see if there is something which is not understood or missed. So types of authorities. Every qualified mujtahid has the right to practice three types of authorities. Wilayatul Ifta, legislative authority, the right to issue a fatwa, law from religious or logical evidences, jurist or legislator, marja', okay? And then Wilayatul Qada, judicial authority, the authority to get involved in judicial or legal system and issue a verdict or hukum khas related to specific cases based on external testimonies and evidences. Here we have a judge. And here, Wilayatul Hakimiyya, the Hakim, whenever people they say Wilayatul Faqih, they mean this type of wilayat, Wilayatul Hakimiyya, where a marja' has an executive body entirely and a political system where his authority governs in that executive body in that country. So the right to issue general verdicts for public on a community level outside of the courtroom or on a larger scale. So this is political leader. So we have Hakim, a mujtahid who gives a hukum, verdict. Fatwa is legislation or hukum, and hukum is on application. Hukum is application on the giving, ruling is giving like verdict. Hukum is application of the legislation, application of the fatwa. Okay, so we have two rulings left and we'll be done for today. And I just explained this. I'm just going to go through it because I just explained this. Ruling number 26, hukum, a verdict. Again, I'll read in Arabic and give the hukum. What are we talking about? Is it fatwa? No. We are talking about a judiciary decree. A judiciary decree, perhaps a political decree. It depends how is the executive body of that political decree. Otherwise, it's a judiciary decree of a courtroom. Hukmul Hakim al-Jami'. Remember the divorce case I said? That there was a divorce case and a mujtahid divorced, and then he was followed to say the Sistani, he wrote to say the Sistani, excuse me, he wrote to say the Sistani that my wife was divorced from me, and so say the Sistani said, well, I mean, I cannot do anything. That's a judiciary decree. That's in that court. And you have to file an appeal to another mujtahid if you have any new evidences or new issues or causes to reopen the case. Otherwise, the case cannot be opened just like because you don't like it. So, حكم الحاكم الجامع حكم الحاكم الجامع للشرائع, the judiciary decree of a qualified mujtahid, or the person who fulfills the conditions of a mujtahid. لا يجوز نقضه. It cannot be nullified or revoked. حتى لمجتهد آخر, even by another mujtahid who is qualified to give a judicial decree, he cannot just go and nullify another mujtahid's decree. إلا إذا كان مخالفا لما ثبت قطعا من الكتاب والسنة. Unless if that decree was against whatever has been proven by certainty from the Quran and the lifestyle of the infallibles alayhi salatu wasalam, the traditions. So if there is a clear ayat in the Quran which is opposing that decree, or clear narration which creates clear authentic narration which opposes that decree, yes, then there's a room to reopen the case. Otherwise you cannot just open the case if there were interpretations based on interpretations. When somebody has different interpretation, no. But if what lima thabata qat'an means for sure, certainly. Now, yes, so now if a mujtahid gives a hukum, does it change the reality? نعم لا يكون حكمه مغيرا للواقع. مثلا من علم أن المال الذي حكم به للمدعي ليس ملكا له لا يجوز ترتيب آثار ملكيته. What is he trying to say here? He's trying to say here that, okay, the judge gave a decree. Okay, now here, for example, we have Muhammad here. Muhammad and me and Muhammad, we had a dispute. There was a $100 bill. Muhammad had signed on it. Some small mark on this $100 bill. I did not know about that. And I stole from him. And now Muhammad says, it's mine. I said, no, it's mine, because I stole. And of course, a person who steals, who lies as well. Haram over haram. So now we went to a judge. A judge, because now it's in my hand. So whenever something is in the hand of a person, the rule of hand is practiced. So Muhammad filed a case against me. And the judge says, Muhammad, do you have two witnesses that this is yours? Or he took it from you? Muhammad said, no, I don't have any witnesses. So he said, okay, who has this $100 bill? He said, he has it. So the judge told me, is it in your hand? Yes, this is the one. And it's mine. Okay, he says, Muhammad, I cannot do anything for you. So the judge gave a decree for me. Okay, Safdar Radhi, this $100 bill is yours. Now the judge gave a hukum. So according to the Islamic legislative system, it's mine. But Muhammad has a mark on the $100 bill. So in reality, it's not mine. I'm a usurper. So if Muhammad finds a chance to take that, because he's for sure, he's a mu'min brother. He's very mu'min, he's God-fearing, he loves God, he's pious, he will never take something which is not his. Now Muhammad has been judged unfair. So now, can he take this $100 bill from me? Because the judge said, it's mine. Muhammad found out one day, I was using the restroom and my wallet was in my hanging on my coat in the masjid. Muhammad came, wallet, okay, it's about time that rule of hand is going to be mine. So he takes the $100 bill, which is his. If it was not his, Muhammad would never take it. It's his. So now Muhammad took that $100 bill. He took his right back because it has his sign in it. He says he's sure, he can swear on the Quran and swear on anything, and he can say, it's mine. But the judge did not listen to him because Muhammad did not have witnesses. So now he took this $100 bill. Now, here's the mas'ala. Can Muhammad use that stolen $100 bill from me, which was his? Yes, he can. Because in reality, waqi', it is his. So the decree of the judge does not change the reality. It's obvious ruling. It's obvious ruling. That means even the judge gave the decree to me, if I use that $100 bill, I'll be considered haram in front of Allah in reality. Though the judge has given it to me. Obviously it's mine. But in reality it is not mine. If I use it, I'm committing haram. He stole it from me. If he uses it, he's not committing haram. You see how it works out? So that is how what this mas'ala says. So look at the wordings back again. Na'am, the decree was given, and another mujtahid cannot nullify this decree. So there was an error in this decree. But na'am, la yakun hukmuhu mughayyiran lil waqi'. The decree does not change the reality, because the decree acts based on the testimonies and evidences. مثلا من علم أن المال الذي حكم به للمدعي. For example, if someone knows that the wealth, that the money $100 bill which I have been given, because I have been given, ليس ملكا له. I said this is my money, but it is not my money. It was given it to me, but it's not my money. لا يجوز ترتيب آثار ملكيته. That means if I want to buy something, that person knows that this is not my money, so he cannot sell me something and take this money, because this money is usurped. This money is usurped. However, if Muhammad stole from me his money, and the seller knows that now Muhammad has his money, though he stole, but no, that seller knows that this is Muhammad's money because he saw the signature being signed by Muhammad on that $100 bill. So therefore, the seller or the buyer, the seller should not take this money from me, because it is not mine in reality. Though the judge gave it to me, but it is not mine in reality. So I hope this is clear. Last ruling. Let me just remind you something. Whenever you see those Indian movies, they have these courtrooms in Indian movie. What do you see? You see a statue of a lady holding a scale, weighing machine, scale in her hand, and she's blindfolded. What does that mean? They say Qanun andha hai, al-Qanun a'ma. The law is blind, because the law doesn't look at the people. If you cry day and night, we are not going to look at their tears. What do you have you can put on the scale? So that's why if I'm a judge, I look at somebody cry, maybe I may get catched by the emotional moments, and I may give and he may be crying or she may be crying, the crocodile tears, you see, they show up, tears, just to get the case. So that's why blindfold, I will not look at you. I have this weighing machine. If you have something which supports your case, put it here, and we are going to measure that you deserve or you don't deserve. But we are not going to look with our eyes. We are going to measure. So that's what we are trying to. So Qanun does not change the reality. Qanun looks at the evidences and testimonies. And an innocent might become guilty, and guilty might become innocent based on the testimonies. But there's nothing the law can do. That's the law. If the law is implemented properly without any corruption, that's what the law does. The law looks at what you have to present from testimonies and evidences, cannot look at you and look at your tears and the way you talk and all those kind of things. Though many courtrooms in the world, they get affected emotionally, and the judges they get, but that's not right. The evidences and the testimonies, they are the decisive tool for judgment. Yes, if the judge knows for reality that a person did not commit crime because he was invited at his house, judge can do some, based on that judge can make a decree because he has the real knowledge. So if somebody has a real knowledge, he can act upon that. Otherwise, everything has to be kept on the weighing machine. So here, let me explain. This is the rule of istishab. Ruling number 23. إذا شك في موت المجتهد. If someone doubts that the mujtahid died or he's still living? أو تبدل رأيه. Did his mas'ala change or it's still the same ruling? We hear that the marja changed the ruling, but we are doubting. Or did something happen to make him unqualified for taqleed? Did he lose some certain aspects of his qualification or not? جاز له البقاء على تقليده. It is permissible for a person to remain on the taqleed of that person who doesn't know he died or something happened which changed his qualification to become unqualified. So until the real state or until the certainty or real state or certain state, until the reality is obvious or until the truth is obvious. حتى إلى أن يتبين الحال إذا شك في موت المجتهد, if there was doubt that the mujtahid died or not, أو في تبدل رأيه, or did his fatwa change or not, أو عروض ما يوجب عدم جواز تقليده, or something happened to him which revokes his qualifications of as a marja, that we can do taqleed to him. جاز البقاء على تقليده. It is permissible to stay on the taqleed until the truth or is known, until the proper state is verified. So here, with this, I'll just give us an example. This is a rule of istishab. Istishab means if you're sure about something and you doubt in the continuation of that thing, then you can stretch the certainty. Ignore the doubt. Stick to the yaqeen. Stick to the certainty. Don't pay attention to the doubt. That is istishab. Grasp to the certainty. If there's a doubt that the certainty has been removed or not, no. Consider the certainty is there and ignore the doubt. This is called istishab. So here, we don't know that mujtahid died or not. Sometimes there may be rumors, oh, marja died, he was in hospitalized. The rumors are, like some say, oh, he died. Some say, no, he's still alive. No, he's dead, he's alive. Sometimes the political things might bring these kind of rumors, like it happened. I don't want to mention the names. There was a marja, he died, but his death was concealed for certain political reasons. So anyhow, so these kind of things sometimes which happen, people, they get doubts. What should we do? Stay on your taqleed until the verification of death is out and everybody knows for sure that your marja died. Okay? For example, this another example, a marja lost his memory. A marja committed something haram, for example, by knowingly, deliberately, not unintentionally, not under circumstances. No. So we don't know that, did he commit haram? Did he have circumstances? Did something happen? Was there some excuse, not excuse? We are doubting in his qualifications as just mujtahid, adil. We are doubting his adalat. We'll say, no, he's still adil. A person is innocent until proven guilty. A mujtahid is adil until it is verified that he has lost his adalah, and so on. So this is a kind of stretching the previous state and ignoring the doubt, which if there was doubt in qualifications about his marja'iyah. By this we end this session. We hope that you benefited. If anything, just email me or WhatsApp me on our WhatsApp. Inshallah, hopefully I'll be able to clarify whatever was not understood here. Ameen. Wa akhiru da'wana alhamdulillahi rabbil alameen. Wa sallallahu ala Muhammadin wa alihi at-tahirin.